sound test 1 2 3, sound test 1 2 3. afternoon, everyone. Ms. Flournoy.
Yes, ma'am.
Good morning. Well, good afternoon. I don't believe I received back the Mr. Tennell's signed documents from you. Did I miss those? I've had so many things coming in.
I'm not sure. Let's see. Well, thought I did, but
I might have missed them.
let me. I'll tell you what, I'm gonna just scan them again and send them again.
Yes, thank you. And I'll print them right out. Good morning to the person who just joined us by the name of good afternoon. I need to have your name, please. You'll need to unmute.
Dewana Irvin.
Miss Irvin. IRVING?
No G.
No G. Okay. Thank you. I see Mr. Johnson. How are you today?
I'm doing all right. What about you?
Fabulous as always.
Splendid.
Good.
I'm just here to serve at the pleasure of the court, as always.
So am I. All right. I will let him know we are just about ready. I'm waiting on one more set of documents and then we'll be on the way. And she's sending them to me right now.
The checkers game where Grand.
You do have Mr. Morris's documents, right?
I do. I have them.
I will talk to him. Yeah, he should be on it.
Yeah, he's there. You can get everybody.
What's it? I already talked to him. I'll double check. Make sure everything goes smoothly.
All right.
Let's finish strong.
We only had 2
2, that's all?
from the jail.
From the jail. Okay,
And
good.
7 off the street.
Okay.
And only 1 gentleman that showed up.
Okay. You might have some Zoomers.
Yeah, most of them.
Sir, I don't mean to sound drastic and hard, but roll tide, sir. Roll tide.
Hey now, none of that roll tide.
Yes, yes. If you're an Auburn fan, the worst thing that you did was hire this guy from Boise State University. Should have hired Hugh Freeze from Liberty. They used to be with Ole Miss. That was the guy that you should have hired. He beat Saban while he was at Ole Miss. Hugh Freeze, he's at Liberty. That's the guy they should have hired. He can recruit.
You made her so mad she clicked off.
Because, well, you got to give the guy a chance, but like I said,
Okay.
Hugh Freeze,
No.
no.
Good afternoon to the courtroom. I just wanted to know that this is DeJuan Washington and I'm here.
Okay.
Got it, sir. I've got you marked. Thank you.
I just sent you the paperwork.
I just heard it. Let me just double check. I got it, Miss Flournoy. Thank you.
Mhm.
Liz, we have a Tony Battle in the audience also. Okay.
Perfect. That's good. Thank you. Clip that for me.
So this is what we got. Got Mr. Morris on his number 1.
Okay, here's this.
Keep going.
That's it. Okay, it's Mr. Tennell that's on. He's number 4 and number 6.
Okay. Cool.
So,
No, Judge Smith, he gonna call him. He gonna call him in order.
that's just him.
Thanks to be. He needs an attorney. He don't.
He
need-
doesn't. He's got Anthony Johnson.
He needs a serious attorney.
Yeah, let's say he has a very good one.
How's your day, Liz?
That's good. How about you guys?
It's cold in
It's
here.
cold in here, but it's been a good day.
It's cold in here.
Now you see.
It's cold up here too at the building, so I think we have all the heaters on.
Must be nice.
I see Mr. Paul Brown over there. How you doing?
Oh.
How you doing, Liz?
Good, good. Good to see you.
Good to be seen.
That's right.
Hey, Vanessa. Miss Florence, are you doing John Morris today?
Liz is shaking her head yes.
Miss Florida, you're muted. Miss Florida, you're muted.
Yes, I am.
Do you have a restitution amount or anything?
No, I do not. Mr. Jones handled this. I'm just doing this part of it. It says the restitution to be determined at a later hearing.
Yeah, well, just to give you a heads up, we're gonna ask for like a 60-day window. I don't anticipate anything, but he doesn't want to get shipped to DOC just to be brought back or anything along. So we're just gonna ask for a 60-day window, just to give you a heads up.
Okay. Okay.
Yeah, because Mark never mentioned anything to me, but
Okay, and I wasn't part of that, so I don't know. But I was told it was to be done today. If you're not ready, we can do it next week.
no, we're ready. We just wanted to put restitution to be determined within 60 days.
Okay. I don't Well, I don't know that I want to put that limitation on it because it may take a little bit longer than that, but I will work to try to get it done as soon as possible.
Okay. All right. I don't know. How you feel?
You're free to have a seat there or here.
I see, you know, I sit every I need.
All right.
Yo.
All right. So far, Mr. Brown's the only one. Yes, oh, I'm sorry, Mr. Washington. Yeah, Mr. Washington's on there. That's all right. You want Washington? He said he was.
Hey, did you say that Tony Battle is in the at the jail there or at the recorder's court?
He's right here in the audience, Mr. Goodman.
Oh, okay. Would you mind just asking him if he signed that accusation at my office?
Okay. Well, you want to talk to him right now? I can bring him up.
Yeah. Oh, that'd be great. That'd be great.
Well, I got sent to this court hearing.
Attorney, Mr. Guzman's right there. Oh, he just needs to ask you a few questions.
Yes, sir.
Mr. Battle. Hold on. There we go. There I am. Hey, did you sign that accusation over at the office?
Yes, ma'am. I just left him over there. I mean, yes, sir. I just left him over there.
Okay. All right. Thank you. Thank you. All right, that's all. That's all I have. Thanks.
It's going to be a short day. Watching the basketball series?
I have not watched any. I just been kind of watching school, but I've been watching baseball.
I have.
I've been watching college ball and I've been watching a lot of spring training baseball.
It's incredible what I see because I mean there's nobody in the audience.
Yeah. All right. Good afternoon.
Good afternoon, Your Honor.
We'll begin with our guilty plea docket. The defendants I have on my docket who will be entering guilty pleas are the following. See if you have the same people. John Morris.
Yes, Your Honor.
Carmoka Fisher, who is not in jail. Is she there or is he there at the jail?
Your Honor, he's not in the audience.
Is he joining us by Zoom? Mr. Guzman?
Your Honor, I did send her the link. She does not appear to be there. So
Okay.
I'll see if I can contact her. And
All right.
maybe she's having some problems with her link.
Maybe so. Number 2, Dowdell, Anthony Dowdell is off. Number 4, Ricky Tennell, Mr. Guzman.
That's correct, Your Honor. You should have the documents on Mr. Tennell.
And
He'll be a plea today.
he is in jail.
All right. He'll need to come down. Next person is Tony Battle, who is not in jail. Is he joining us, Mr. Guzman?
Your Honor, he's there at the Recorder's Court.
All right. He needs to sit on the bench where the defendants will be sitting in just a moment so that I can advise him. And number 7, Jawan Washington.
Your Honor, Mr. Washington is present by Zoom.
All right. Courtney Gunn is off. Brianna Price is not in jail. Is she there at Recorder's Court?
No,
Yeah.
no.
She's joining us also by Zoom.
All right. Thank you. All right. Let me just make sure. Ms. Little, are you with us?
Yes, sir, I'm here.
All right. Miss Leonard, are you with us?
Judge, I'm here.
All right. And the very first person I mentioned was John Morris. So if they're at the jail, you would bring those defendants who are in custody into the courtroom and have those who are not in jail come sit in the same area with those defendants. I'll then advise them of their constitutional rights.
For now. One of them is your client. So if that ask rule over, so you get the guy. I'll do whatever you need me to do. Thank you, man. Thank you. You can have that seat right there.
Which is a much comfortable seat.
Hey, I need to put a little cushion or something on this thing here.
Man, it's comfortable to me.
And you want to?
Especially when you sit in this doggone thing all day.
Appreciate Right here.
Yeah, he just been given an advisement of the right.
All right. Catch me now, ready?
Yeah, go ahead. That's good.
Okay.
Perfect.
Let's see, can we do the camera a little wider angle there? I only see 3 defendants.
That's right. There's only 3 defendants, Your Honor.
Okay.
Who are on
Mr.
Zoom. Okay, let's see. How is that, Your Honor? Better?
That's better. Let's see here. Good morning. Good afternoon, Ms. Flournoy.
Good morning.
All right. All right. So I have, if you would just raise your hand when your name is called. John Morris. Did Karamoka Fisher join us, Mr. Guzman?
He has not, Your Honor.
Okay. Ricky Tennell. All right. Tony Battle. All right, sir. Joanna Washington. All right. And finally, Brianna Price.
I'm right here.
All right, thank you. All right, if you would each raise your right hand to take an oath. Do you each solemnly swear or affirm that any testimony you give in court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you. All right. I understand that each of you has indicated a desire to enter a guilty plea to the charges currently pending against you, but before I can consider accepting the guilty plea, I'm going to advise you of your constitutional rights so that when you come up individually to enter your guilty plea, you'll be doing so with an understanding of those rights. These proceedings are being taken down verbatim by the official court reporter. So when you answer your question, please answer out loud in a strong voice so that she can record your answer. Is there anyone among you who is not a U.S. citizen? If you're not a U.S. citizen, raise your hand. Okay, and we'll take that to mean that everyone is a U.S. citizen. Do you each understand that you have the right to plead not guilty and demand a jury trial, in which case the state of Georgia must prove your guilt of each element of each offense with which you're charged beyond a reasonable doubt? Does everyone understand that?
I do, Your Honor.
Thank you. Mr. Washington, turn on your microphone.
Yes, I do.
All right. Gentlemen there at the jail, did you all hear and understand the question?
Yes, sir. Yes.
All right, thank you. Do you understand that if you plead not guilty, the Constitution guarantees you at trial, among other possible rights, the following: the right to a speedy and public trial by jury, the presumption of innocence, the right to confront and to question the witnesses against you, the right to subpoena witnesses and evidence in your favor. You would also have the right to the assistance of an attorney. And if you could not afford the services of an attorney, one would be provided to you by the state of Georgia at no cost to you. Does everyone understand these rights so far?
Yes, sir, Your Honor.
Honor.
You would have the right to testify and to offer other evidence during your trial, but you would also have the right not to incriminate yourself. Stated in a slightly different way, you would have the right to testify if you wished, and no one could stop you from testifying. On the other hand, if you did not wish to testify, no one could force you or compel you to testify, nor even comment on that decision in front of a jury or hold it against you in any way. Does everyone understand?
Yes, sir, Your Honor.
Thank you. Do you understand that if you plead not guilty or simply remain silent, the court would enter a not guilty plea for you, and you would secure a jury trial with all of the rights that I've just outlined for you? Does everyone understand?
Yes, sir, Your Honor.
Yes, Your Honor.
All right, thank you. And finally, do you understand that if you plead guilty, as I understand you wish to do, you will be giving up or waiving those rights? Does everyone understand?
Yes, Your Honor.
All right, thank you. Just a couple of more advisements. If this may or may not apply to your particular case, but if there is a special condition of probation in your case requiring that you waive your rights under the Fourth Amendment to the U.S. Constitution, I want you to understand what that means. A Fourth Amendment waiver means the following: that you would agree that as a special condition of probation that you would submit yourself to a search of your person or property at any time of the day or night, with or without your consent, and with or without a search warrant, whenever requested to do so by a law enforcement or a probation officer. It further means that anything that might be found or taken as a result of such a search could be used as evidence against you in any court proceedings. Does everyone understand?
Yes, Your Honor.
Your Honor.
All right, thank you. Now, just by a show of hands, do any of you own or possess a license or a permit to carry a weapon?
No,
Anyone?
Sir, Your Honor.
All right. Anyone there at the jail? All right. Now, if your sentence requires that you serve time in custody, I would advise you of the following consequences of escape. If after having been convicted and sentenced to confinement, you should intentionally escape from lawful custody or any place of lawful detention, you could be charged with the additional felony offense of escape, which upon conviction is punishable by a period of up to 10 years in the state penitentiary. If, however, you escape while armed with a dangerous weapon upon conviction, you could be sentenced to a period of up to 20 years in the state penitentiary. Does everyone understand?
Yes, sir, Your
Yes.
Honor.
Mr. Washington,
Yes, sir, Your Honor.
they're at the jail.
Yes, sir.
Everyone understand? All right. You have certain rights post-conviction. If you believe there have been any irregularities in these proceedings, you have the right to file a writ of habeas corpus. But there are certain time limitations that apply. Such a writ must be filed in the case of a felony within 4 years of today's date. In the case of a misdemeanor, you have only 1 year from today's date to file that writ. And in the case of a traffic misdemeanor, you have even less time to file your writ. You have only 180 days from today's date. Does everyone understand this?
Yes, sir,
Yes,
Your
sir,
Honor.
Your Honor.
Thank you. One additional thing, you may have signed a piece of paper saying that you don't have the right to file an appeal from a guilty plea, but I advise you that you do have the right to file an appeal if you believe that's appropriate. But you must do so by filing a written notice of appeal and filing it with the clerk of the Superior Court of Muskogee County, Georgia, within 30 days of today's date. Does everyone understand this right?
Yes, sir, Your
Yes,
Honor.
sir, Your
All right, thank you. We'll begin with Mr. Morris, and we'll come to the others in order.
Yeah, stand right up for me. Walk over there with you. You gotta stay right there, okay? Thank you. We got it right. We got it.
Your Honor, are you ready to proceed?
I am. Ms. Flournoy, if you would begin by stating the factual basis for the charges against Mr. Morris and the recommended sentence that you have negotiated with Mr. Morris and his standby counsel, Mr. Anthony Johnson, who appears with him there at the county jail at the recorder's court. Whenever you're ready, Ms. Flournoy.
Your Honor, this is a case of the state of Georgia versus John Arthur Morris. It was indicted on the SU 17 CR 3478. It is my understanding that an accusation was filed, so I will be doing a null pros for that particular case. And the new case.
When your taxes are extended, you get a free tablet and a chance to win a BMW 6.
Hold on just a second. Who's giving us the benefit of a commercial?
Judge, I'm sorry, they're muted now.
Okay, thank you.
We will be proceeding on the case number SU 21 CR 639. And it is a 14 count indictment, Your Honor. It will take a few minutes to go through the factual basis.
And Judge, for the record, I have spoken with Mr. Morris, and from my understanding, since the state is deciding to proceed on a new accusation, procedurally wise, Mr. Morris has agreed to waive formal arraignment as well as indictment if necessary, Your Honor.
All right. Thank you. Thank you for perfecting the record, Mr. Johnson. Go ahead, Ms. Flournoy.
Okay, Your Honor. On May 13, 2016, there was a call for in reference to an armed robbery at the AutoZone located at 6450 Flat Rock Road in Columbus, Muskogee County, Georgia. The manager there was a Mr. Gary Davison, and when the police officer arrived, he indicated that a black male had entered the store. had a pistol and ordered that they go into the office. He zip tied some of the employees, but basically one employee had to open the safe, and he took approximately $22,160 from the store at that time, and that's the basis of charge number one. On May the 23rd, again, there was a call about a armed robbery taking place at the Auto Zone on 3580 Victory Drive, Columbus, Muskogee County, Georgia, involving a black male. He entered the store wearing a long sleeve gray shirt, black pants, and this was approximately at 8 o'clock in the morning. Went to the rear of the store. A Mr. Williams working that morning. The defendant put a mask on his face and came to the front of the store again, stated to Mr. Williams that he was going to rob him. Mr. Williams indicated that he didn't have time for the foolishness. The defendant basically wanted him to take him to the safe. Another employee came into the store. Ultimately, the defendant did not leave the store with anything, but he did put a gun onto Mr. Williams, demanding that he take him to the safe. On May 23rd, 2016, a little bit later that morning at about 8:50, the police got a call for another Advanced Auto Parts on 1501 Manchester Expressway, Columbus, Muskogee County, Georgia, was in progress. Again, it was a black male, entered the store. The clerk at that time became suspicious. Given his experience, he just thought the person was suspicious, start to engage him in conversation, asking him, did he need any help or anything. At some point, the defendant disappeared, and then he reappeared with a mask on. He wanted him the clerk to give him the money. The clerk was Mr. Jarman, Chris Jarman, and he proceeded to give him the money out of the cash register, which was about $300. And then he said, give me the money out of your pocket. Mr. Jarman was an African-American male. He said, not you, as he started to give it to him. He said, no, not you, the white guy. And at that point, Mr. Murray gave him the money out of his pocket. The defendant fled the scene after that happened. On May 29th, 2016, there was a call to another call at Advanced Auto, 6451 Veterans Parkway, Muskogee County, Georgia. And again, a black male came in, entered through the front door, walked around to the rear of the store, placed the mask over his face, and he was walking towards the counter, and told them to open the safe. He made them lay on the floor. He got approximately $120 in currency from the cash drawer, another $145 in a Blue SunTrust bank deposit bag, and $883.75 in a clear SunTrust deposit bag. He left the store. And again, he had a weapon a pistol. He pointed a pistol at them and told them to open up the safe, and he took the money. On July 1st, 2016, this was another armed robbery at 1505 Manchester Expressway, Columbus, Muskogee County, Georgia. This was at the Golden Corral. It was approximately about 9:30 that night. They were getting ready to leave. The manager, Miss Brenda Waters, said she was at her door, a driver's door to her vehicle, at the end of business, and she noticed she had walked her employees to the car, and she saw those two same employees coming towards her again with an unknown black male walking behind them. That male ordered her to return to the inside of the building as he showed her a handgun. After entering the right door, he had the first two employees to lay on the floor near the office door. And then he asked if anyone else was in the building. And he followed her to the kitchen where he ordered two more employees to lay on the floor. And the manager said she tried to tell them to call 911, but basically was cut off by this black male. She opened the safe, and there were 3 cash trays in there, filled with $300 each, and 2 separate stacks of cash. One was $2,880, and the other was $900. And then there was approximately about $200 in rolled quarters. He then made her drop him off. He got in her car and made her drop him off between the McDonald's and the Save-A-Lot grocery store. On July 16, 2016, at about 8 p.m., this was a call again to the Auto Zone on 6450 Flat Rock Road, Columbus, Georgia, Muskogee County. Again, a black male entered with a weapon, came in, put on a mask, used a weapon, and had a handgun and wanted them to provide him, take them to the safe and provide him the money from the store. And again, he took at that time he took approximately $1,200 from that location. Your Honor, this is the sentence recommendation is on count 1, robbery by force, reduced from armed robbery, 20 years, served 7 in the Department of Corrections. Count 2, possession of firearm during the commission of a felony, it will be null pros. Count 3, criminal attempt to commit a felony, 5 years to serve, concurrent to count 1. Count 4, possession of firearm during the commission of a felony, null pros. Count 5, robbery by force, reduced from armed robbery, 20 years, served 7 in the Department of Correction, concurrent to count 1. Count 6 will be null pros, which is a possession of firearm during the commission of a felony. Count 7, robbery by force, reduced from armed robbery, 20 years, served 7 in the Department of Correction, concurrent to count 1. Count 8, possession of a firearm during the commission of a felony, will be null pros. Count 9, robbery by force, reduced from armed robbery, 20 years, served 7 in the Department of Correction, concurrent to count 1. Count 10 is possession of a firearm during the commission of a felony. You will know there's a motion to null pros that. Count 11 is robbery by force, reduced from armed robbery, 20 years, served 7 years in the Department of Correction, concurrent to count 1. Count 12 is possession of a firearm during the commission of a felony. That will be null pros. Count 13 is robbery by force, reduced from armed robbery, 20 years, served 7 in the Department of Correction, concurrent to count 1. Count 14 is possession of a firearm during the commission of a felony. That will be null pros. The special conditions of probation are restitution to be determined at a later hearing. Upon release from incarceration, defendant shall immediately report to his probation officer. 4th Amendment waiver. And Your Honor, I will make a note for the court that the paperwork we submitted was under the old indictment number. So we would ask that the correction be made to reflect the current case number.
All right. Thank you, Ms. Flournoy. Mr. Morris, did you hear and understand the sentence recommendation from the district attorney?
Yes, sir.
Are you in agreement with that recommendation?
Yes, sir.
Other than the recommendation, has anyone offered, promised, or given you anything in exchange for your guilty plea?
No, sir.
Has anyone used any force or any threat of force against you to secure your guilty plea?
No, sir.
Have you been asked to read or sign anything in connection with this case that you do not understand?
No, sir.
Now, I noticed that you have signed and you have initialed the document entitled Advice of Rights for a Plea of Guilty. Are those in fact your initials and your signature on that document?
Yes, sir.
Now, you're proceeding pro se, and you and I have had a colloquy before where we discussed the desirability of having counsel or the danger of not having counsel. Do you recall those hearings?
Yes, sir.
But you have elected to have Mr. Anthony Johnson serve as your standby counsel. Is that correct?
Yes, sir.
And has he gone over these different 21 items that are listed on the advice of rights form with you?
Yes, sir.
And are you satisfied with the explanation you've received from Mr. Johnson respecting your rights?
Yes, sir.
Okay. Mr. Morris, this is a question I ask every defendant in a guilty plea, and it doesn't suggest anything. It's just something for the record. Have you ever been treated for a mental illness?
Yes, sir.
You have? Okay, tell me about that, please.
Depression, anxiety, post-traumatic stress.
Okay. All right. Was that before these incidents occurred or after you were taken into custody, or both?
Before.
Before. All right. Are you receiving any treatment there at the county jail for those conditions?
Yes, sir.
Is the treatment helping you?
Yes, sir.
Do the treatments in any way interfere with your ability to make a decision for yourself?
No, sir, it doesn't.
All right. So you're clear-headed about what you're doing in court today. Is that true?
Yes, sir.
All right. Other than any prescription medication you may be receiving, are you under the influence of alcohol, drugs, narcotics, or any medication this afternoon?
No, sir.
All right. Thank you, sir. For the record, I will ask, is Mr. Morris eligible to be sentenced as a first offender?
He is not, Your Honor.
Thank you. Now, Mr. Morris, you were present in court a little while ago when I advised all defendants of their constitutional rights. First of all, is that true?
Yes, sir.
Were you able to hear and understand the advisement of rights?
Yes, sir.
Okay. You also raised your right hand and took an oath to tell the truth, I believe. Is that true?
Yes, sir.
You're still under oath. Is everything that you've told me so far and that you will tell me as we go through your guilty plea going to be the truth, Mr. Morris?
Yes, sir.
All right, thank you. Now, a special condition of your probation will be that you waive your rights under the Fourth Amendment to the United States Constitution. And Mr. Morris, that's a valuable right that we enjoy. Did you hear and understand the advisement regarding the meaning of such a waiver?
Yes, sir.
Are you in agreement with such a waiver?
Yes, sir.
Mr. Morris, do you freely and voluntarily admit your guilt to the charges you face?
Yes, sir, I do.
Do you admit the facts as alleged by Ms. Flournoy?
Yes, sir.
Do you now wish to enter your plea of guilty?
Yes, sir, I do.
All right. Although you do represent yourself, you're a self-represented litigant or a pro se, You have had the benefit of standby counsel. Is that true?
Yes, sir.
Have you found the services of Mr. Johnson to be beneficial to you?
Yes, sir, I do.
All right. I'm sure. All right. Is there anything you'd like to say, Mr. Morris? You don't have to say anything.
Yes, sir. As to the matter of restitution that's in his paperwork, I would like to know, can we deal with that so I won't have to come back from prison and try to deal with, can we deal with that situation now?
All right. Ms. Burdette, there in the victim advocate office, do you have the amount of restitution, or perhaps Ms. Flournoy, you have that amount that I can go ahead and incorporate in the sentence?
Can you put a timeline on it, sir?
Well, let me get a answer to my questions to these two ladies. Do either of you have the total amount of restitution from the victim?
Your Honor, I do not have the total amount at this time, but as I spoke to Mr. Johnson earlier, I will make an effort to get the total restitution as soon as possible. We can set it down for a date. I would say in May, to give me adequate time to make sure I get it. If I get it before then I can provide it to the court and Mr. Johnson.
Okay. All right. I'll set a restitution date of not more than 45 days from today's date. If the state and Mr. Morris are able to agree on an amount, it won't be necessary to have a hearing.
Yes, sir.
If not, and the victims wish to be heard on that issue, they'll have that opportunity within 45 days of today's date. Are the victims or their representatives aware of this guilty plea today?
Yes, Your Honor, they are aware of it. The ones that I was able to get in touch with, the other ones, I'm still working on reaching them. As far as restitution goes, I am in the process of reaching out to the corporate offices for the businesses to see what amount they're asking for. And then some of the individual victims only listed contact information for the actual business they were working at. And they're no longer employed there. So I'm still in the process of reaching out to them for restitution information.
All right. Thank you, Ms. Burdette. All right. Mr. John Arthur Morris, the court finds that you understand the nature of the crimes and the consequences of your guilty plea.
I apologize. Mr. Morris is, there's one other thing that he wanted to articulate to the court, from my understanding. Yes, sir.
All right.
Your Honor, I've been incarcerated for over 4.5 years, and since being incarcerated, I've lost everything, my home, job, and everything, and I basically have nothing to go home to once I make parole. And I just want to know if it's possible, can you make a recommendation that I receive the transitional center to make that transaction a little bit smoother for them?
All right. I'll do that, Mr. Morris.
Yes, sir. Thank you, sir.
You're welcome. All right. I'll ask you this, Mr. Johnson. You have been good enough to serve as standby counsel for Mr. Morris. Do you believe that Mr. Morris understands his constitutional rights as advised by the court?
I do, Your Honor.
Do you believe that he has and he is making a knowing, intelligent, free, and voluntary decision to enter this guilty plea?
Yes, Your Honor.
Is there anything that Mr. Morris has authorized you to say on his behalf?
Nothing further, Your Honor. I believe
All right.
I articulated everything.
All right, thank you. Mr. John Arthur Morris, the court finds that you understand the nature of the crimes and the consequences of a guilty plea.
Yes, sir.
The court finds that there's a strong factual basis to support your guilty plea. The court finds that you understand your constitutional rights. And the court makes a further finding that you have and you are making a knowing, intelligent, free and voluntary decision to enter this guilty plea, which I will accept. And I will sentence you in accordance with the recommendation if you will sign the charging instrument, which is now a newly drawn accusation. Let's see if that's been done.
It has been signed, Your Honor.
All right, thank you, Mr. Johnson. With that being the case, I do accept your guilty plea, Mr. Morris, and I sentence you as follows. This is in the case of SU 21 CR 639, which is the new accusation against you. And Mr. Johnson has said on your behalf that you waive indictment and you waive arraignment. Is that in fact correct, Mr. Morris?
Sir.
All right, here's your sentence. Count 1, robbery by force, which was reduced from armed robbery, 20 years, served 7 years with the Department of Corrections. Count 3, criminal attempt to commit a felony, 5 years to serve concurrent with count 1. Count 5, robbery by force reduced from armed robbery, 20 years, served 7 years in the Department of Corrections, concurrent to count 1. Count 7, robbery by force reduced from armed robbery, 20 years, served 7 in the Department of Corrections, concurrent to count 1. Count 9, robbery by force reduced from armed robbery, 20 years, served 7 in the Department of Corrections, concurrent with count 1. Count 11, robbery by force reduced from armed robbery, 20 years, served 7 in the Department of Corrections, concurrent to count 1. Count 13, robbery by force reduced from armed robbery, 20 years, served 7 in the Department of Corrections, concurrent with count 1. Special conditions of probation will be that you make restitution in an amount to be determined within the next 45 days, either by agreement or through a hearing. Upon release from incarceration, you shall immediately report to the Georgia Department of Community Supervision. And while on probation, your rights under the Fourth Amendment to the United States Constitution are waived. Now, having successfully entered a guilty plea to counts 1, 3, 5, 7, 9, 11, and 13, and on the state's motion, counts 2, 4, 6, 8, 10, 12, and 14 are null pros. That is the sentence of the court. Do you have any questions about your sentence?
No, sir, I don't.
All right. It is the court's desire that when your time of incarceration comes to an end and you are transitioning to either parole or probation, that the Department of Community Supervision, that the Department of Corrections transition you from a prison to some setting that will better acclimate you to a return to life among society. That will, however, be up to the discretion of the Department of Corrections. Did you hear and understand the advisement regarding your rights to file a habeas corpus petition?
Yes, sir.
Did you hear and understand the advisement regarding your rights to file an appeal to a higher court?
Yes, sir.
All right. I would further advise you that you are a convicted felon and you may never possess a firearm or ammunition as those terms are defined by the official code of Georgia. Do you understand, sir?
Yes, sir.
All right, Mr. Morris, I know you've had a long time to think about this since you were taken into custody. I will say for the record that you will receive credit for time served. Good luck to you in completing your period of incarceration and then returning and successfully completing your probation. Thank you.
Thank you, Your Honor.
Thank you, Mr. Johnson.
Mr. Johnson, this officer standing at the probation office. Will you check that message and send me his personal information?
That's what I just want to tell you. I'm going to get it from him right now. When I get to my office, I'm going to shoot it to you, all right?
All right, thank you.
All right. Let's next take Brianna Price, to be followed by DeJuan Washington. All right, Mr. Guzman, are you ready?
Yes, sir.
Ms. Flournoy, are you ready for the state?
Your Honor,
Yes, Your Honor, we are.
that's all I have for this afternoon, Judge. May I be excused?
Yes, sir, Mr. Johnson.
Thank you, Your Honor.
Thank you.
Your Honor, this is the case of the state of Georgia versus Brianna Nicole Price. Case number SUCR 2217. It's a 3-count indictment. She's charged with possession of a controlled substance. In count 1, the recommendation is 3 years probation. Count 2 is possession of a drug-related object. 12 months probation concurrent to count 1. Count 3 is with marijuana, possession of less than an ounce. We will know across that. The special conditions are 120 hours of community service and a 4th Amendment waiver.
All right.
Your Honor, the facts on this particular case are that on November the 22nd, 2019, the officer made a traffic stop on Sidney Simons Boulevard in Muskogee County. The defendant was a passenger in that car. One of the passengers in the front seat jumped out the car, and the officer went after them, and the driver of the car took off again, and there was a second traffic stop on the vehicle for failure to maintain lane. And the defendant was a passenger in that vehicle. The officer smelled the odor of marijuana coming from the car and did a search of the car, and in a black backpack in the right rear passenger area where the defendant was seated, that contained 24 grams of marijuana in 3 little separate baggies in a small box that contained approximately 1 gram of cocaine. And that's the basis, the factual basis for this particular case. And she did claim possession of it, as well as the other, some of the other occupants it identified as her backpack.
All right, thank you. Good afternoon, Ms. Price.
Good afternoon.
You were joining us by Zoom a little earlier this afternoon, as I recall. Were you able to hear and understand the advisement of rights that I gave to you and the other defendants?
Yes, sir, Your Honor, I was.
Did you also raise your right hand and take an oath to tell the truth?
Yes, sir, I did.
Thank you. You're still under oath, and Ms. Price, I'll have a few questions for you as we go through your guilty plea, and I'd like to be able to count on you to answer my questions truthfully. May I do that?
Yes, sir, Your Honor.
Thank you. Did you hear and understand the sentence recommendation from the district attorney?
Yes, Your Honor.
Are you in agreement with that recommendation?
Yes, sir, Your Honor, I am.
Other than that recommendation, has anyone offered, promised, or given you anything in order to convince you to enter a guilty plea?
No, sir, Your Honor, they haven't.
Thank you. Has anyone used any force or any threat of force against you to secure your guilty plea?
No, sir, Your Honor.
Have you been asked to read or sign anything in connection with your case that you do not understand?
No, sir, Your Honor.
All right. Have you ever been treated for a mental illness?
No, sir, Your Honor, I have not.
This afternoon, are you under the influence of alcohol, drugs, narcotics, or any medication?
No, sir, I am not.
Are you clear-headed about what you're doing in court today?
Yes, sir, Your Honor, I am.
All right, thank you. Is Ms. Price eligible for sentencing under the Georgia First Offender Act? And if so, does she wish to avail herself of such a sentence, Mr. Guzman and Ms. Flournoy?
She is, Your Honor, and she would ask the court to consider first offender.
Any objection from the state?
No objection from the state, Your Honor.
All right, thank you. Ms. Price, the First Offender Act carries some very definite benefits for someone who successfully completes their probation under that sentencing statute. There are some risks, and in no way am I trying to dissuade you from being sentenced as a first offender. I just want you to be aware of a couple of things. The most serious offense that you face today, is possession of a controlled substance, which is a felony which carries a sentencing range of from 1 to 3 years in the state penitentiary. And you'll see the importance of that in just a second. The possession of drug-related objects is a misdemeanor that carries a sentencing range of up to 12 months in the county jail. Now, if you as a first offender probationer violate the terms and conditions of your probation, and you are later adjudicated by the court to be guilty of these charges, the court may impose at a resentencing hearing any sentence which was permitted by law today for the offenses of which you would then have been found guilty. At a probation revocation and adjudication of guilty hearing, you as a first offender probationer could be resentenced to up to 3 years in the state penitentiary and 12 months in the county jail. Do you understand that?
Yes, sir, Your Honor.
If that event were to occur, that you violated your probation and you were resentenced, you would, however, receive credit for any time you either served already in custody or any time you had served on probation. Do you understand that, ma'am?
Yes, sir, Your Honor, I do.
With that understanding in mind, would you like for me to sentence you under the First Offender Act?
Yes, sir, Your Honor.
That's what I will do then.
Your Honor, I forgot to make the disclosure about my previous employment with the Public Defender's Office. Just so that the defendant is aware of that, I don't, an opportunity to waive any potential conflict of interest.
All right. Ms. Price, Mr. Guzman has probably covered this with you, but before Ms. Flournoy was an assistant district attorney, she worked for the Public Defender's Office in this circuit. Mr. Guzman, does your client understand that, and does she waive any potential conflict?
He does, Your Honor. Actually, I believe Ms. Flournoy had already left the office before we got Ms. Price's file.
All right. Well, I know that Ms. Flournoy, out of an abundance of caution, always likes to put that on the record. So do you understand that, Ms. Price?
Yes, sir, Your Honor, I do.
Is that a problem for you?
No, sir, Your Honor, it is not.
Okay. All right. Thank you. All right. Did you hear and understand the advisement regarding a Fourth Amendment waiver, what that means?
Yes, sir, Your Honor, I do.
Are you in agreement with that?
Yes, sir, Your Honor.
Okay. All right. Ms. Brianna Nicole Price, the court asks you the following questions. Do you freely and voluntarily admit your guilt to the charges you face?
Yes, Your Honor.
Do you admit the facts as alleged by the district attorney?
Yes, Your Honor.
Do you now wish to enter your plea of guilty?
Yes, sir, Your Honor.
Thank you. You're represented by Mr. Jose Guzman, who also participates in this hearing via the Zoom platform. Have you had enough time to discuss your case with Mr. Guzman?
Yes, sir, Your Honor.
Are you satisfied with the representation you received from Mr. Guzman?
Yes, sir, Your Honor. He's been great.
I'm sure he appreciates that. Ms. Price, is there anything you'd like to say? You're not required to say anything, but this is your opportunity if you wish.
No, sir, Your Honor. Just thank you.
You're welcome. You're going to be sentenced in just a moment under the provisions of the Georgia First Offender Act. That act was passed for people in circumstances similar to yours who find that they have violated the law and wish to take care of the matter and move on and not violate the law in the future. And are you committed to that, Ms. Price?
Yes, Your Honor, I am.
All right. Mr. Guzman, have you had enough time to prepare for this hearing today?
Yes, sir, I have.
Do you believe that your client understands her constitutional rights?
Yes, sir.
Do you believe that she has and she is making a knowing, intelligent decision to enter this guilty plea?
I do, Your Honor.
Other than to ask the court to follow the recommendation, is there anything further you'd like to say on behalf of Ms. Price?
No, Your Honor.
Ms. Price, I find that you understand the nature of the crimes and the consequences of a guilty plea. The court finds that there's a strong factual basis to support your guilty plea. The court finds that you understand your constitutional rights, and the court further finds that you have and you are making a knowing, intelligent, free, and voluntary decision to enter your guilty plea, which I will accept, and I will sentence you in accordance with the recommendation. And I'm going to look at the accusation here. And it appears that you and Mr. Guzman have signed it. So I do accept your guilty plea, and I sentence you as follows. Count 1, possession of a controlled substance, 3 years probation. Count 2, possession of drug-related objects, 12 months probation, concurrent or at the same time with count 1. Special conditions of probation will be that you perform 120 hours of community service and that your rights under the Fourth Amendment to the United States Constitution are waived while you're on probation. That is your sentence. Do you understand your sentence?
Yes, sir, Your Honor, I do.
All right. Do you have any questions about what happened in court today?
No, sir.
Did you hear and understand the advisement regarding your right to file a habeas corpus petition?
Yes, Your Honor.
Did you hear and understand the advisement regarding your right to file an appeal to the appellate courts in Georgia?
Yes, Your Honor, I did.
Okay. Now, although you're being sentenced as a first offender and you're not pleading guilty to a felony, you are prohibited from owning or possessing a firearm or ammunition, as those terms are defined by the official code of Georgia, while you're on probation. Do you understand, Ms. Price?
Yes, sir, Your Honor, I do.
All right. Very good. Make sure you perform your community service and that you have nothing in your possession that would cause a Fourth Amendment waiver to be a problem for you.
Yes, Your Honor.
You understand?
Yes, sir.
No one wants to see you back in court on a probation revocation petition.
Thank you.
Good luck to you. Good luck to you in fulfilling the terms of your sentence. And if you have no questions, that concludes your sentencing hearing today.
Thank you, Your Honor.
Good luck to you.
Thank you.
All right. Now, Dewan Washington.
Yes, sir, Your Honor, I'm here.
All right.
Your Honor, this is a case of the state of Georgia versus DeJuan Washington, SU 20 CR 1349.
And Your Honor, on Mr. Washington, the defense will stipulate to the factual basis.
Let's see what we have here, Mr. Usman.
Or if you want me to proceed?
Go ahead and put the facts on the record, since he's pleading to something other than what he was accused of.
Your Honor, this happened on Columbus State University. He was found in possession of marijuana. It was the possession with intent was based upon his indication that he may have sold some marijuana previously on campus. So he was charged with the possession with intent. But based on the quantity, our recommendation is that it be reduced to the lesser included offense of possession of marijuana less than an ounce. Other than his words, there was nothing to indicate that this was a possession with intent. So our recommendation is that it be reduced and he'll be allowed to plead to the lesser included offense of possession of marijuana less than an ounce, 12 months probation. On possession of a drug-related object, 1 to 12 months sentence range, 12 months probation concurrent to count 1. The special conditions are a $1,000 fine, 40 hours of community service, and a Fourth Amendment waiver.
Is a $1,000 fine in connection with count 1, the possession of less than an ounce of marijuana?
Yes, Your Honor, it is.
We had a modified.
I'm sorry, did I? Okay.
It was 150 hours.
That's correct.
Of community service. I think that's.
I'm sorry, I must be looking at the one in the file. I didn't get the most current one, but that is correct, Your Honor. It was 150 hours. He's still a student in school and could not afford the fine, so we did 150 hours of community service in lieu of a fine.
All right, that's
My
fine.
apologies.
That's fine. Excuse me 1 second. Mr. Washington, did you hear and understand the sentence recommendation from the district attorney?
Yes, Your Honor.
Is that what you agreed to before we began these proceedings?
Yes, Your Honor.
You were present via Zoom earlier when I advised all defendants of their constitutional rights. Is that correct?
Yes, Your Honor.
Were you able to hear and understand what was being said?
Yes, sir, Your Honor.
All right, thank you. You also raised your right hand, as I recall, and took an oath to tell the truth. Is that correct?
Yes, sir, Your Honor.
You're still under oath, and I'll have a few questions for you as we go through your guilty plea, and I'd like to be able to count on you to answer truthfully. May I do that, Mr. Washington?
Yes, sir, Your Honor.
Thank you. All right. Now, you understand you're pleading guilty this afternoon. Is that correct?
Yes, sir, Your Honor.
Now, the sentence that we heard from Ms. Flournoy, are you in agreement with that sentence?
Yes, sir, Your Honor.
Other than the offer of this sentence recommendation, has anyone offered, promised, or given you anything in exchange for your guilty plea?
No, sir, Your Honor.
Has anyone used any force or any threat of force against you to secure your guilty plea?
No, sir.
Have you been asked to read or sign anything in connection with this guilty plea that you do not understand?
No, sir.
Right. Have you ever been treated for a mental illness?
No, sir.
This afternoon, are you under the influence of alcohol, drugs, narcotics, or any medication?
No, sir, Your Honor.
Are you clear-headed about what you're doing, Mr. Washington?
Yes, sir, Your Honor.
Okay. Is Mr. Washington eligible to be sentenced as a first offender? And if so, does he wish to avail himself of such a sentence for what now will be 2 misdemeanor counts? Mr. Guzman.
He is eligible, Your Honor, and he would ask the court to consider first offender.
He wishes on these misdemeanors to be sentenced as a first offender?
Yes, sir. I know it's unusual to ask a first offender on it's not unusual, I suppose, but it's typically not done. But in this particular instance, Mr. Washington sees the benefits for a future career and any other issues that he may face with a conviction of this sort. So he wants to go ahead and ask for first offender, and I've explained it to him I do believe that he understands the pros and cons.
Okay. Does the state have an objection to first offender, Ms. Flournoy?
State has no objection, Your Honor.
Oh, okay, all right. Mr. Washington, it seems to the court that you've carefully considered seeking first offender act sentencing, and I intend to honor that request. Mr. Guzman, I'm sure has advised you of both the advantages and the risk. There is some risk, and in no way am I trying to dissuade you from seeking such a sentence. I just want you to know what the risk could be. If you, as a first offender probationer, violate the terms and conditions of your probation, and this court or another court later adjudicates you guilty of these charges, the court at that point may impose any sentence permitted by law for the offense that you, the probationer, has been found guilty of committing. Therefore, at a probation revocation and adjudication of guilt, a first offender probationer may be resentenced to a sentence which is greater than that which is imposed today at the entry of the original plea. You would, however, receive credit for time served either in custody or on probation against such a sentence. Now, you are entering a guilty plea to a misdemeanor, possession of marijuana less than an ounce, which is a misdemeanor and carries a sentencing range of from 1 to 12 months in the county jail. You're also entering a guilty plea to another misdemeanor, possession of drug-related objects, which carries a sentencing range of from 1 to 12 months in the county jail. If you were adjudicated guilty and you came back before the court and you were resentenced, you could be sentenced to 12 months on each count, and they could be ordered to be served consecutively, one after the other, for a total of up to 24 months in the county jail. Do you understand that, Mr. Washington?
Yes, sir, I do.
And with that understanding in mind, would you like to be sentenced as a first offender?
Yes, sir, I do.
All right, then I will so sentence you. Did you hear and understand the advisement regarding the meaning of a Fourth Amendment waiver?
Yes, sir.
Do you agree to those conditions?
Yes, sir.
Mr. Washington, do you freely and voluntarily admit your guilt to these two charges?
Yes, sir.
Do you admit the facts as alleged by the district attorney?
Yes, sir.
Do you now wish to enter your plea of guilty?
Yes, sir.
You're represented by Mr. Jose Guzman, who joins us this afternoon via the Zoom platform. Have you had enough time to discuss the case with Mr. Guzman?
Yes, sir, I have.
All right. Are you satisfied with the representation you received from Mr. Guzman?
Yes, sir, I am.
Is there anything you'd like to say? You're not required to say anything, but this is your opportunity.
Yes, sir. I have a letter that I'd like to present to you, the courtroom, and my family.
Would you like to read that into the record?
Yes, sir.
Okay, go right ahead.
2 years ago, I made the biggest mistake of my life. I come forward today to announce I have learned from my wrong decision makings. Others make mistakes and keep doing wrong. I've honestly learned from my one misconception. I'm grateful and blessed for life lessons that was presented to me. During that time of my life, I was down. It was during our playoffs time for the football team, and I just pulled my hamstring. Me and my mother wasn't on the best of terms at that point, and this was my first time being away at college by myself. I felt alone and felt like I had no one to turn to, so I turned to illegal substances to cope with my pain. I felt at my lowest in the jail cell, and I made a promise to myself I'll overcome and prosper this situation. Since then, I was able to be back permitted into Columbia State University and participate with the Baptist Collegiate Ministry. Now I'm a student athlete at Savannah State University. My classification is a junior, and I'll be graduating with a bachelor's degree next year. Despite all the adversity I faced, last semester I was able to maintain a 4.8 GPA. I know that I disappointed my family and my support system. I want them to know I'm genuinely sorry, and I'll never jeopardize my future nor my life ever again.
Well, Mr. Washington, that's a very strong statement on your part, and it shows a real level of maturity that the court recognizes, and I'm sure your family joins with you in recognizing that you have recognized the mistake and you intend not to repeat that mistake. So I commend you for your statement. Mr. Guzman, do you believe that Mr. Washington understands his constitutional rights?
Yes, sir.
Have you had enough time to prepare for this hearing today?
I have, Your Honor.
Other than to ask the court to follow the recommendation, is there anything further you'd like to say on behalf of this young gentleman?
Yeah, just a couple of things. I was going to ask the court if it would consider making the probation unsupervised once Mr. Washington completes his community service. It is 150 hours community service, and just depending on where he's able to finish that up, whether it's in Savannah or in Atlanta, it's going to be here in the state, of course. Once he completes that, I mean, it's probably going to be a few months out. So I would ask the court to consider that. Also want the court to know that I'd sent several documents to Ms. Flournoy, and that was part of the reason that Ms. Flournoy decided to reduce the charges in this particular case. Part of those documents included information regarding scholarship opportunities that Mr. Washington had and is taking advantage of, his scholastic records, part of which, or actually I sent all of those to Ms. Flournoy, and I wanted the court to just be aware of all that and everything that Mr. Washington has done. He's kept in contact with me for months and months, and actually more than a year since this case has been kind of lingering around for quite a while, a couple of years at this point. But also wanted the court to know that he does have family support. Here on the Zoom call with him are his mother, Miss Irvin, his stepfather, Rory Walker, and I believe a coach over at CSU, Michael Spite, is also on. And I didn't know if any one of those individuals wanted to say anything in support of Mr. Washington. I see all three of them on, but they are all muted, but they are here and present and supporting.
Hi, Judge. How are you?
I'm well. Tell us who you are.
My name is Dewana Irvin. I'm Dewan Washington's mother. I greatly appreciate the determination of everything, and I also feel that yes, something had to be done, because no matter what you go through in life, you don't turn to negativity. And I do believe wholeheartedly that he has learned from this. We've never had any real issues out of Dewan from throughout his whole life. But again, as he got older and sometimes being with the wrong crowd and things of that nature, and us being displaced from with each other, we grew together. I was a teenage mom, so we're pretty close in age. And with him going off to college and being one place and me being somewhere else, it was kind of like a distant thing where he didn't know how to express himself about me having him go there and me being somewhere else. But again, like I told him, you have mentors, you have people in your life that you can talk to and communicate with, and you have a career. He's a straight A student. I don't know if they sent over that paperwork, but he's a straight A college student. I'm in college and I don't make straight A's. But for something to happen like this, again, I believe that things happen for a reason. And through this and the things that he's endured throughout the last almost 2 years, it's been a drastic change. And I just want to thank everybody for being here with him and showing him that everyone deserves a second chance.
Well, that's a strong testament from Mr. Washington's mother. Thank you for joining us. Anything else, Mr. Guzman, before I pronounce the negotiated sentence?
Oh, Mr. Spite, I believe, looks like Mr. Spite is trying to get our attention there.
All right.
Hello, Judge. Thank you a lot for allowing me to present in this courtroom. I took a chance on Mr. Washington 2 years ago here at Columbus State University. I'm the head football coach here at our prestigious university here in Columbus. The one came here as a football player, and he ended up being my top receiver. That's how he ended up leaving me, because he was too good. So he ended up venturing off to another university, which I think he stopped through at Valdosta for a little while, and now he's at Savannah State. And he's always been a good kid, great kid. Like I say, we took a chance on him here at Columbus State University. He did go through some adversity, which is why we're here now. And I've been in contact with him since this situation happened, and even the things that happened on campus. I was his academic advisor on campus. And he's actually done everything that the university asked him to do. He completed everything. And I was expecting his grades to really slip, which they didn't. Because most time kids go through situations, their grades normally slip. But the ones did a good job of maintaining his grades, keeping himself together, working with his family and his teammates. And support system it is strong here, because I treat my guys like family. So the guys, he has a big family here at Columbus State University. I just want to say thank you for giving the opportunity to speak on his behalf.
Well, thank you, Coach, for joining us on this Zoom hearing today. I'm sure that means a lot to your player, Mr. Washington, that you're willing to take the time to speak up on his behalf. Mr. Guzman, anyone else?
Yeah, I see Mr. Walker is still on. I didn't know if he wanted to say there he is. Rory Walker, Your Honor. I see you. Mr. Walker, can you hear us?
Yeah, I'm just gonna chime in.
Seems to be some questions of strength of signal there. I'm going to assume Mr. Walker would amen what's already been said.
Amen. Amen.
Okay.
Yes.
Anyone else, Mr. Guzman?
No, Your Honor.
All right. Thank you. Mr. Dwayne Washington, the court finds that you understand the nature of the crimes and the consequences of a guilty plea. The court finds that there is a factual basis to support the charges against you in your guilty plea. The court finds that you understand your constitutional rights, and the court makes a further finding that you have and you are making a knowing, intelligent, free, and voluntary decision to enter this guilty plea, which I will accept. And I will sentence you in accordance with the recommendation as I see that you and Mr. Guzman have signed the accusation. So I will accept your guilty plea and I sentence you as follows. Count one, possession of marijuana with intent to distribute, now reduced to the lesser included offense of possession of marijuana less than an ounce. The sentence is 12 months probation. Count two, possession of drug-related objects, a misdemeanor, 12 months probation concurrent to count one or served at the same time.
Peyton?
You'll perform 150 hours of community service as directed by the Mr. Paul Brown, who is on this Zoom call for the Georgia Probation Service. And that community service is in lieu of a fine. Your rights under the Fourth Amendment to the U.S. Constitution are, however, waived while you're on probation. You're being sentenced under the provisions of the Georgia First Offender Act, which we've covered. Is there any objection by the state to Mr. Washington's probation becoming non-reporting probation once he completes his community service, Ms. Flournoy?
Your Honor, the state has no objection.
All right. Then as your attorney requested for you, Mr. Washington, as soon as you complete your 150 hours of community service, your probation will convert to non-reporting. You'll still be on probation, but you simply will not have to report or pay fees.
Yes, sir, Your Honor, I understand.
All right. Now, did you hear and understand the advisement regarding your habeas corpus rights?
Yes, sir.
Did you hear and understand the advisement regarding your Fourth Amendment rights?
Yes, sir.
And finally, did you hear and understand the advisement regarding your rights to file an appeal if you believe that's appropriate?
Yes, sir.
All right. Good luck to you, Mr. Washington. Sounds like you've got a good support network and a bright future ahead of you. I don't ever want to see you in court under these circumstances again.
Yes,
Okay?
sir.
You're welcome. Take care now.
You too.
Thank you,
Your Honor.
Mr. Washington, this is the probation office. You'll need to contact us tomorrow. Are you living locally or you live out of town?
I'm living in Savannah, Georgia right now.
I can give you a number to call tomorrow. We can arrange your probation.
Yes, sir.
706-507-1735.
Hold on. Can I get that?
706. And this, Mr. Guzman, do you want to provide that to him?
I can. 507-1735.
Thank you. That's Miss Benton's number.
Okay.
Okay.
All right. Thank you.
All right. Thank you.
All right. Now let's go to Ricky Tennell. If he could be brought back into the courtroom.
You know, he's present there at in the
I
courtroom.
see him. All right. Thank you.
And just so the court is aware, he's on two cases here. He's number 6 and number 4. But a new accusation is being filed, Your Honor, that's combining those 2 cases.
Well, are we ready to proceed this afternoon?
Yes, sir. I sent the new accusation has been signed. All the documents have been signed, but that new accusation has that been filed? Has the new accusation been filed? Okay.
Yes, it has. We're proceeding under SU 20 CR 131.
I have only one sentence recommendation form though, Mr. Guzman.
It's all the cases were combined, Your Honor, into one accusation.
All right, I see, Ms. Flournoy. Mr. Tennell, were you in the courtroom there earlier this afternoon when I advised all defendants of their constitutional rights?
Yes.
Were you able to hear and understand what was being said?
Yes, sir.
Okay. You also raised your right hand and took an oath to tell the truth. Do you remember that?
Yes, sir.
And you remain under oath, and I'll have some questions for you as we go through your guilty plea, and I would expect you to answer my questions truthfully. Can I rely on that, Mr. Tennell?
Yes. Yes.
Thank you. Ms. Flournoy, the factual basis and your recommendation.
Your Honor, this defendant on 2 occasions broke into the Blue Water Grill that's located at 4641 Springs Road, Columbus, Muscogee County, Georgia. On November the 20th, he broke in there. There is a video surveillance of his when he broke into there on December the 17th also. And at that time, he used a hammer. And that's the basis of the possession of a tool for the commission of a crime. He used a hammer in breaking into, as part of his breaking into that establishment on the 23rd. Our recommendation is on count 1, burglary, 2nd degree, 5 years, served 30 months in the Muscogee County Prison, credit for time served, and the balance on probation. Count 2 is burglary, 2nd degree, 3 years probation, consecutive to count 1. Possession of a tool for the commission of a crime, 3 years probation concurrent to count 2. Special conditions is a Fourth Amendment waiver, restitution in amount to be determined. Do not approach within 1,000 feet of the scene of the crime, and no contact with the victim or witnesses in this case.
All right. Mr. Tennell, did you hear and understand the sentence recommendation?
Yes, sir.
Are you in agreement with that recommendation?
Yes, sir. There's one question. Do I get credit for the time I've been in the county jail? 2 for 1
Yes.
on that?
Well, I can't tell you about any multiple credit. I can tell you you'll receive credit for time served. That's up to the sheriff to calculate your time before you're transported to the Muskogee County Prison. Do you understand? I can't represent to you that you'll get 2 for 1, but you will at least get 1 for 1.
My understanding was I'd received 2 for 1 on the credit.
Let me explain this on the record, because I explained this to Mr. Tennell, Judge, and I just want to make sure that he understands. He's getting credit for the time that he's been in, and of course, the sheriff will create an affidavit custodian's affidavit saying how much time that he's actually been in. Whether or not the jail or Muskogee County Prison gives him 2 for 1 is up to the Muskogee County Prison or the jail, depending on. I think it's going to be the Muskogee County Prison will make that determination. It's not something that the judge actually will say on the sentence. It's just part of kind of historically their practice there at the Muskogee County Prison, which is what I explained to you, kind of like how they do it there at the Muskogee County Jail. But it's not something that the court would actually order.
In fact, Mr. Tennell, if I said you would get 2 for 1 credit, it would have no effect. The execution of the sentence is performed by the executive branch of government, and they have their rules. I think what Mr. Guzman is telling you is correct. Historically, I understand that people who have been at Muskogee County Jail and who have not had problems are given multiple credit, but I can't order them to do that, and I don't want to give you any false assurance. So if your plea is contingent on that, you don't have to enter a guilty plea.
Am I eligible for 2 for 1 on that sentence? That's what I'm asking.
You're asking me questions I can't answer. So you're going to have to go on faith on that part.
He can't be your lawyer.
All right.
Okay, did that answer your question as best we could?
Yes, sir, I guess.
Well, let's not have any guessing about this. Do you want to proceed with your guilty plea or go to trial?
I need to waive this hearing right here.
You mean you want to withdraw?
Sir,
Okay.
my understanding was from my attorney, I was receiving 2 for 1 on the 30 months credit for time served. That was my understanding on the emails, everything I've received from him.
Well, I expect Mr. Guzman is giving you the benefit of his experience, but Mr. Guzman can't promise you that any more than I can promise you that.
All right, Your Honor, I want to proceed.
You do or do not?
Yes, sir.
All right. Let me get the paperwork back. Thank you. All right, we've heard the factual allegations and the sentence recommendation. Are you in agreement with that recommendation, Mr. Tennell?
Yes, sir.
All right. Now, other than the sentence recommendation, has anyone offered, promised, or given you anything to convince you to enter a guilty plea?
No, sir.
Has anyone used any force or any threat of force against you to secure your guilty plea, sir?
No, sir.
All right. Have you been asked to read or sign anything in connection with your case that you do not understand?
Just what I was asking you, that was all.
I'm sorry, say that again.
I was asking you, that's what I couldn't understand.
Okay. All right. Thank you. Is Mr. Tennell eligible to be sentenced as a first offender?
He's not, Your Honor.
Mr. Tennell, have you ever been treated for a mental illness?
No, sir.
This afternoon, are you under the influence of alcohol, drugs, narcotics, or any medication?
No, sir.
Are you clear-headed about what you're doing, sir?
Yes, sir.
Okay. Now, a special condition of your probation will be that your rights under the Fourth Amendment to the U.S. Constitution are waived. First of all, do you understand that that is a special condition?
Yes, sir.
Did you hear and understand the advisement I gave you and the other defendants regarding the meaning of such a waiver?
Yes, sir.
And are you in agreement with that waiver?
Yes, sir.
Thank you. Mr. Tennell, do you freely and voluntarily admit your guilt to the charges you face?
Yes, sir.
Do you admit the facts as alleged by the district attorney?
Yes, sir.
Do you now wish to enter your plea of guilty?
Yes, sir.
You're represented by Mr. Jose Guzman, who is participating in this hearing through the Zoom platform, as we all are today. Have you had enough time to discuss your case with Mr. Guzman?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Is there anything you'd like to say?
Is this here with my probation revocation too, Your Honor?
I don't have anything on a probation revocation here. Mr. Guzman, Ms. Flournoy, is there such a petition?
There is a revocation, and the intention was for this to, I believe the intention was for this to run concurrently with that revocation. I believe I don't know if Officer Stan, you know what, it's not on the docket, so Officer Stan probably doesn't have that information. But there is a revocation.
I'm here, Your Honor. If you give me 1 second, I'll take a look. It appears he is under Officer Fry. That's case SU 19 CR 1201. It has an expiration date of April 1st, 2027. I can pull a copy of the, I don't have a copy of his petition, but I can look at the delinquency report, and it looks like the recommendation on that was 3 years to be revoked, and looks like 30 months, so it's a difference of 6 months there.
Your Honor, I had spoken with Officer Pryor on this about our recommendation, and he was agreeable to something that would be compatible to this and for it to run concurrent.
If you'd like, Your Honor, I can send an email over to Officer Fry and get that petition sent over nunc pro tunc, or I can attempt to get him on the phone and see if he can join in, whatever the court would like.
Well, the district attorney represents the Department of Community Supervision. Ms. Flournoy, is it your representation that you spoke to the community supervision officer and he was agreeable to the 30-month revocation concurrent with the new law violations?
Yes, Your Honor.
Is that agreeable to you, Mr. Tennell?
Yes, sir.
Okay. And that'll be the sentence of the court, but I do need to tell you a couple of things here. In the probation matter, you have the right to an actual probation revocation hearing where you would have just about the same rights that you would have in a trial on the new charges, with two big differences. One is on a probation revocation, you do not have the right to a jury trial. The judge sits as the judge of the facts and the law. Also, the burden on the state to show that you violated your probation requires a lesser showing than the burden which is required on a new law charge. When I was advising you and the other defendants, I spoke of the state's obligation to prove your guilt beyond a reasonable doubt. In a probation revocation hearing, the burden on the state is to show what is known as a preponderance of the evidence that you violated your probation. And that's a lesser burden. Preponderance of the evidence basically means it's more likely than not that you've violated your probation. First of all, do you understand what I just said?
Yes.
And do you waive your right to a formal probation revocation hearing?
Yes, sir.
All right. Well, Mr. Tennell, you've had a couple of good questions this afternoon. I hope that you're satisfied with the answers. Mr. Guzman, have you had enough time to prepare for this hearing today?
Yes, sir.
Do you believe that your client understands his constitutional rights?
I do, Your Honor.
Do you believe that he has and he is making a knowing, intelligent, free, and voluntary decision to enter his guilty plea to the new charges and also to waive his rights to a formal probation revocation hearing in the probation matter and to agree to a partial revocation of his probation in the old case?
Yes, sir. I do.
That's a compound question. I apologize for that, Mr.
That's all right.
Guzman, but I believe you understood what I was asking.
Yes, sir.
All right. Mr. Ricky Al Tennell, the court finds that you understand the nature of the crimes and the consequences of a guilty plea. The court finds that there's a factual basis to support your guilty plea and also your stipulation on the probation matter. Court finds that you understand your constitutional rights and that you've made a knowing, intelligent, free, and voluntary decision to enter your guilty plea and your stipulation, which I will accept. And I see that you have signed the charging instrument. So I do accept your guilty plea and I sentence you as follows. Count 1, burglary in the second degree, 5 years, served 30 months in the Muskogee County Prison, credit for time served, the balance on probation. Now there's another count 1. I guess that's from the old case. Is that right, Ms. Flournoy?
Yes, Your Honor, we should recount too.
Okay, so it's burglary in the second degree also. The sentence in that case is 3 years probation consecutive to count 1. And then the possession of tools for commission of a crime count is 3 years probation concurrent to count 2. Special conditions of probation will be a waiver of your Fourth Amendment rights, restitution in an amount to be determined within the next 45 days. Do not approach within 1,000 feet of the scene of the crime. No contact with the victims or witnesses in the case. Now, in your probation case, which was referenced on the record, 30 months of probation are revoked to confinement concurrent with the sentence in the new cases, also with credit for time served. That is the sentence.
Your Honor, can we make that, just to make sure that it's, there's no question about it, can we make that 30 months revoked to MCP concurrent to that count 1?
Yes, we'll do that. 30 months revoked to MCP concurrent with the sentences in the new cases and with credit for time served. That's your sentence, Mr. Tennell. Do you have any questions?
No.
Did you hear and understand the advisement regarding your constitutional right to file an appeal?
Yes, sir.
Did you hear and understand the advisement regarding your habeas corpus rights?
Yes, sir.
Did you hear and understand the advisement regarding the consequences of a guilty plea?
Yes, sir.
I mean, consequences of escape, having now been convicted.
Yes, sir.
Okay. I have a question for you. You can answer it or not answer it. Why was the Blue Water Grill a target? Do you have some connection with that business?
Your Honor, I took this plea bargain. I mean, to keep from.
Okay, that's fair enough. I was just curious. All right. Good luck to you, Mr. Tennell.
Yes.
I just enjoy eating there, and I wondered why it was his target.
John, I eat there too, me and my family. So it is what it is. Speaking of, before you call this other case, I can understand the Washington case, Coach. I coach at the Skoke County School District for like 16 years. I'm at Hardaway for my 6th year going. So I do understand how the kids they're good. Majority of kids are good kids. Some of them just make bad decisions.
Well, that's right. That's right. And that's why the Georgia General Assembly a number of years ago provided for a first offender sentence. Let's have Mr. Tony Battle come out.
He's going to come in front of you, Honor. He's in the audience.
All right, thank you. Good afternoon, Mr. Battle.
How you doing, sir?
Doing well, thank you. Let's see here what these charges are. All right, you have a misdemeanor case this afternoon.
Yes, sir.
All right. Mr. Battle, were you present in the courtroom there earlier this afternoon when I advised everyone of their rights?
Yes, sir.
Were you able to, did you understand what was being said?
Yes, sir.
Did you also raise your right hand and take an oath to tell the truth?
Yes, sir.
You're still under oath, Mr. Battle, and I'm going to count on you to answer my questions truthfully. May I do that?
Yes, sir.
All right, thank you. Ms. Flournoy, if you would.
Yes, Your Honor. This is State of Georgia versus Tony Battle, SU 20 CR 307. On June the 13th, 2019, the officers responded to 3800 South Lumpkin Road, Columbus, Georgia, Muskogee County, in reference to a threat, and the victim, Reginald Taylor, indicated that he was threatened by text by the defendant. And the text message basically stated that gonna see how good my fight game is. I might even kill him tomorrow. Based on that, it was charged as a misdemeanor terroristic threat. So our recommendation is 12 months probation, a $500 fine for special conditions, no contact with the victim, Reginald Taylor.
All right. I do not have the accusation, a copy of the accusation. Ms. Flournoy, can you or Mr. Guzman get that over to us so that we have the full package?
Give me a minute, Your Honor, and
sure,
I'll get it.
Judge, I apologize. This is Liz. I do have it. I'll print it now. I'm sorry.
Thank you. All right. All right, Mr. Battle, did you hear and understand the sentence recommendation?
Oh, yes, sir, but I was told it was a $100 fine.
Well, the paperwork I have says a $500 fine. Can be up to $1,000 on a misdemeanor, but Mr. Guzman, do you have a way of communicating privately with your client? I mean, if that's the difference in entering a plea or not entering a plea, you need to discuss that.
Yeah, the paperwork I've got says $500 on it. I don't really have a way to communicate with Mr. Battle at the moment.
Your Honor, if he will agree to it, I will reduce it in half, but not to 100, to 250. But I will not go to 100.
Did you hear that, Mr. Battle?
Yes, sir, I agree to it.
You agree to it. All right. Let me make a change here. Now, Mr. Battle, other than the recommendation, has anyone offered, promised, or given you anything in exchange for your guilty plea?
No, sir.
Has anyone used any force or threat of force against you to secure your guilty plea?
No, sir.
Have you been asked to read or sign anything in connection with your case that you do not understand?
No, sir.
Have you ever been treated for a mental illness?
No, sir.
This afternoon, are you under the influence of alcohol, drugs, narcotics, or any medication?
No, sir.
Are you clear-headed about what you're doing?
Yes, sir.
Okay. Is Mr. Battle eligible to be sentenced as a first offender? And if so, does he wish to avail himself of such a sentence in this case?
Your Honor, he's not seeking first offender.
All right, thank you. Mr. Battle, do you freely and voluntarily admit your guilt to the charge you face?
Yes, sir, I do.
Do you admit the facts as alleged by the district attorney?
Yes, sir.
Do you now wish to enter your plea of guilty?
Yes, sir.
Mr. Battle, you're represented by Mr. Jose Guzman, who participates in this hearing through the Zoom platform, as do we all today. Have you had enough time to discuss your case with Mr. Guzman?
Yes, sir.
Are you satisfied with his representation?
Yes, sir, very much.
I'm sure he appreciates that. Is there anything further you'd like to say, Mr. Battle? You're not required to say anything, but this is your opportunity if you wish.
I just like to say that I like to start letting my anger get the best of me to say stuff I don't really mean.
Okay. Well, do you resolve not to do that in the future?
I do, sir.
Okay, good. All right, Mr. Guzman, is the sentence recommendation that we heard from Ms. Flournoy the same sentence that you negotiated for Mr. Battle?
It is, Your Honor.
Have you had enough time to prepare for this hearing today?
Yes, sir.
Do you believe Mr. Battle understands his constitutional rights?
I do, Your Honor.
Do you believe that he has and he is making a knowing, intelligent, free, and voluntary decision to enter this guilty plea?
Yes, sir.
Other than to ask the court to follow the recommendation, is there anything further you'd like to say on his behalf?
No, Your Honor.
Mr. Tony Terrell Battle Sr., the court finds that you understand the nature of the crime and the consequences of a guilty plea. The court finds that there is a factual basis to support your guilty plea. The court finds that you understand your constitutional rights, and the court makes a further finding that you have and you are making a knowing, intelligent, free, and voluntary decision to enter this guilty plea, which I will accept and sentence you in accordance with the recommendation, as I now see that you have signed the accusation along with Mr. Guzman. So I do accept your guilty plea and I sentence you as follows. Count 1, terroristic threats, in this case a misdemeanor, 12 months probation, pay a fine of $250, no contact with the victim, Reginald Taylor. That is your sentence. Do you understand your sentence?
I do, sir.
Did you hear and understand the advisement regarding your habeas corpus rights?
Yes, sir.
Did you hear and understand the advisement regarding your right to file an appeal?
Yes, sir.
Do you have any questions about what went on in court today?
No, sir.
All right. Good luck to you, sir.
Thank you, sir.
Judge, Mr. Battle will need to report to the Georgia Probation Office at 430 First Avenue tomorrow at 3:30.
Okay, thank you, sir.
Okay.
That man sounding good.
No, just go down First Avenue. Go all the way down here like you're going towards Golden Park and that little whiskey store right there. And you'll see Georgia, say Georgia Probation Service.
Okay. Oh, yeah, before you walk across the bridge,
Yeah.
that's off right there.
Mhm.
All right, I got you. All right. Yeah.
All right. The only case we haven't handled is the Kamoka Fisher. Did he or she ever show up there at the jail or otherwise make contact with you, Mr. Guzman?
Your Honor, I think I'm not sure. There's someone in the middle of my Zoom here. It says iPhone. That may be Miss Fisher, but I don't know if she can hear me right now. I see she lives in Montgomery, and so I may not have made it clear to her that it was 1:30 Eastern time.
She is can hear. She we might just need to get her attention a little bit. Miss Fisher. I think she hears us. Miss Fisher, you're
Ms.
muted.
Fisher? Ms. Fisher?
Yes.
Okay.
Ms. Fisher. Ms. Fisher, if you can stabilize your phone or your camera, it would be a big help to me. Can you do that? Because I'm seeing ceiling tiles and other people around you. Just keep it focused on your face while we're having this hearing. Can you do that, ma'am?
Yes.
All right. All right. Ms. Fisher, were you on the, you were not on the Zoom, or maybe you were. Were you on the Zoom earlier this afternoon when I advised everyone of their rights?
Yes.
Were you able to hear and understand what was being said?
No.
Yes, Your Honor, or no, Your Honor, ma'am?
Your Honor, I don't think she was present when you went over the rights.
Okay. All right, then we'll go over them again. Ms. Fisher, I'm only going to continue this hearing if you get the phone focused on your face and keep it there. Okay. Ms. Fisher, if you would please raise your right hand and take an oath. Do you solemnly swear or affirm that any testimony you may give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, Ms. Fisher. This is, we'll just go straight through the guilty plea. You understand this is a guilty plea, is that correct?
Yes.
It's either yes, sir, or yes, Your Honor.
Yes,
Fisher.
sir.
All right, that's a matter of respect to the court, not to me as an individual. Ms. Flournoy, if you would please state the factual basis and your recommendation.
Your Honor, this happened on May 18th, 2019. There was a call to 5550 Whittlesey Boulevard, which is the TJ Maxx store, in reference to a shoplifting. And upon arrival, the store personnel indicated that three people had been in the store, 2 Black females and 1 Black male, shoplifting several items, but they had left the store when the officers got there. The store personnel indicated that they thought they had gone down to Ross in a gold Mercury Grand Marquis. They were located, and numerous items with store tags were located inside the vehicle. The total amount of merchandise that was recovered from the vehicle was $1,405.58. And that's being the basis for the felony theft by shoplifting charge against the defendant. Your Honor, the recommendation is just 1 count indictment, 5 years probation. The special conditions are a $1,000 fine. She's eligible for first offender, 40 hours of community service, 4th Amendment waiver, stay away from the TJ Maxx located at 5550 Whittlesey Boulevard, Columbus, Georgia. If she elects first offender and if it's requested and granted, behavior incentive date 2 years from the date of sentence.
All right, thank you, Ms. Flournoy. Ms. Fisher, did you hear and understand the sentence recommendation?
Yes, sir.
Are you in agreement with that recommendation?
Yes, sir.
Now, other than that recommendation, has anyone offered, promised, or given you anything in order to have you enter a guilty plea?
No, sir.
Has anyone used any force or any threat of force against you to secure your guilty plea?
No, sir.
Have you been asked to read or sign anything in connection with your case that you do not understand?
No, sir.
Okay, good. Have you ever been treated for a mental illness?
No, sir.
This afternoon, are you under the influence of alcohol, drugs, narcotics, or any medication?
No, sir.
Are you clear-headed about what you're doing this afternoon, ma'am?
Yes, sir.
Good. Now, the district attorney has told me that you're eligible to be sentenced under the Georgia First Offender Act. And I suspect strongly that Mr. Guzman has talked to you about such a sentence, the advantages of such a sentence, and also the risk.
Mm-hmm. Yes, sir.
The advantages are that if you complete your probation successfully, at some point in the future, an order will be presented to me to sign discharging you on this case, and you will not have a felony conviction on your records. And most people think that's a valuable thing to be able to answer truthfully, that they do not have a felony conviction. It has an impact on your ability to secure employment or seek higher education. Those are on the good side. Now, these are the things that I want you to consider, and in no way am I attempting to dissuade you from being sentenced as a first offender. I just want to make you aware of this. Now, the charge against you is theft by shoplifting. It's a felony, and it carries a sentencing range of from 1 to 10 years in the state penitentiary. Do you understand that?
Yes, sir.
And the reason that's important is what I'm about to tell you. If you, as a first offender probationer, violates the terms and conditions of your probation, and the court later adjudicates you guilty or finds you guilty, the court may impose any sentence permitted by law for the offense the probationer has been found guilty of committing. Therefore, at a probation revocation and adjudication of guilt hearing, a first offender probationer may be resentenced to a sentence which is greater than that which is imposed today at the entry of the original plea. If you were to be so resentenced, you would receive credit for time already served in custody or time you had already served on probation. Ma'am, do you understand that?
Yes, sir.
And with that understanding, would you like to be sentenced under the Georgia First Offender Act?
Yes, sir.
Then I intend to do that. Ms. Fisher, are you a citizen of the United States?
Yes, sir.
Do you understand that you have the right to plead not guilty and demand a jury trial, in which case the state of Georgia must prove each element of each offense with which you're charged beyond a reasonable doubt? Do you understand that?
Yes, sir.
Do you understand that if you plead not guilty, the Constitution guarantees you at trial, among other possible rights, the following: the right to a speedy and public trial by jury, the presumption of innocence, the right to confront and to question the witnesses against you, the right to the assistance of a lawyer during such a trial, and if you cannot afford the services of a lawyer, one would be provided to you by the state of Georgia at no cost to you. Do you understand?
Yes, sir.
Thank you. Do you understand that you would have the right to testify during such a trial and to offer evidence? But you would also have the right not to incriminate yourself. In other words, if you wish to testify, no one could stop you from testifying. On the other hand, if you did not wish to testify, no one could force you to testify, nor even mention your decision not to testify in front of a jury or hold it against you in any way. Do you understand, ma'am?
Yes, sir.
Do you understand that if you plead not guilty or simply remain silent, the court would enter a not guilty plea for you, and you would secure a jury trial with all of the rights that I've just outlined for you? Do you understand,
Yes,
Ms.
sir.
Fisher? And do you understand further that if you plead guilty, as I understand you wish to do this afternoon, you would be giving up or waiving those rights? Do you understand?
Yes, sir.
Thank you. Now, there is a special condition of your probation which requires that your rights under the Fourth Amendment to the United States Constitution be waived while you're on probation. And Ms. Fisher, that's a valuable right that we enjoy, and I want you to understand what you're giving up. Do you agree, as a special condition of your probation, that you will submit to a search of your person or property at any time of the day or night, with or without your consent, and with or without a search warrant, whenever called upon to do so by a law enforcement or a probation officer? Do you understand and agree?
Yes, sir.
Do you understand and further agree that anything that might be found or taken as a result of such a search may be used as evidence against you in any court proceedings? Do you understand that?
Yes, sir.
Do you agree to that?
Yes, sir.
Thank you. Ms. Fisher, do you freely and voluntarily admit your guilt to the charge you face?
Yes, sir.
Do you admit the facts as alleged by Ms. Flournoy, the Assistant District Attorney?
Yes, sir.
Do you now wish to enter your plea of guilty?
Yes, sir.
Ms. Fisher, you're represented by Mr. Jose Guzman, who is participating in this hearing today via the Zoom platform, as are we all. Have you had enough time to discuss your case with Mr. Guzman?
Yes, sir.
Are you satisfied with his representation?
Do I have to do 40 hours of community service?
Yes, ma'am. That's what you apparently agreed to.
I told him that he asked me would I pay a higher fine instead of community service because I work and I don't know when I have time to do community service.
Well, the Senate's recommendation is that you serve 5 years on probation, that you pay a $1,000 fine plus statutory penalties and add-ons, that you perform 40 hours of community service, that your rights under the Fourth Amendment be waived, that you stay away from TJ Maxx locations located at 5550 Whittlesey Boulevard, Columbus, Muskogee County, Georgia, and that if you are sentenced under the first offender statute, the state is asking the court to provide for a behavioral incentive date of 2 years from today's date. Now, that's what was represented to me as what had been agreed to. Is there something else, Mr. Guzman, that your client perhaps is expecting that isn't on this recommendation form?
Yeah, I think that I'm just looking at the prior, any prior plea sheets. I believe that the community service and the fine were different, and we actually came to this $1,000 fine and 40 hours community service. Like, I think there was a greater amount of community service and a lower fine. So we increased the fine. Is that what you recall, Ms. Flournoy? I thought that we had increased the fine and just reduced the community service, but hadn't eliminated completely.
I don't remember, but I can.
There were several.
Because you're right, we went through a lot, so.
Right, and I believe in talking to Ms. Flournoy, because I mentioned that to Ms. Flournoy, she didn't put as much community service as she would have.
Exactly, we did reduce it.
Because in similar cases, we've been doing like 80 hours community service. And so this was actually a little bit less than what she had been recommending.
Yes. Yeah, you're correct. And I think probation, if she feels that she can't do it, I think probation will work with her to, I think they work with her if she's unable to do the community service. Is that not correct, probation?
We would have to prepare an order and have it, you would have to agree upon it, and then it would be sent to the judge. If it's your intent now that she not do any community service and raise the fine, we would ask to save those extra steps and not have to prepare an order later down the road.
Well, my intent was, I thought the community service was necessary. That's the reason why it's on there, because I think she needs to do the community service given the nature of the charges against her. I just felt that the community service was important with regards to this particular sentence.
Well,
I will say this from the state perspective, Your Honor. If the court desires to change it to a fine, the state will not object to it, but we're not going to change our recommendation at this point. But if the court feels it's appropriate, we will not object to the court taking that action.
All right, Mr. Guzman, what I think I would be comfortable in doing is raising the fine to $1,400 and eliminating the community service altogether. So 1,400 plus statutory penalties and add-ons. I know you have no way of privately communicating with your client unless you want to have her mute her sound and give you a phone call. And if you want to do that, that's fine.
Ms. Fisher, did you hear the $1,400 and?
Oh, the money is good. The money's no problem.
Okay. Okay.
All
So,
right.
all right.
Okay. All right. Mr. Guzman, I don't know if I got this far along, but have you had enough time to talk with Ms. Fisher and prepare for this hearing today?
I have, Your Honor.
Do you believe that she understands her constitutional rights?
Yes, sir.
Do you believe that she has and she is making a knowing, intelligent, free and voluntary decision to enter this guilty plea?
I do, Your Honor.
All right. Thank you. I see that the Ms. Fisher, the court finds that you understand the nature of the crime and the consequences of a guilty plea. The court finds that you understand your constitutional rights. The court finds that you have and you are making a knowing, intelligent, free, and voluntary decision to enter this guilty plea. And I will accept your guilty plea and sentence you as follows, since you have signed the charging instrument, it appears. All right, I accept your guilty plea and I sentence you as follows. Count 1, theft by shoplifting, a felony. 5 years probation. Special conditions of probation. $1,400 is a fine plus statutory penalties and add-ons. No community service. A waiver of your rights under the Fourth Amendment to the U.S. Constitution. Stay away from the TJ Maxx located at 5550 Whittlesey Boulevard, Columbus, Muskogee County, Georgia. A behavioral incentive date of 2 years from today's date is set in this case. That is your sentence, Ms. Fisher. Do you have any questions about your sentence or your special conditions?
No, sir.
All right. You have the right to file a habeas corpus petition if you believe there have been any irregularities in this hearing, but if you wish to do so, you must do so within 4 years of today's date. You also have the right to file an appeal to an appellate court in the state of Georgia, but in order to do so, you must file a written notice of appeal and file it with the clerk of the Superior Court of Muskogee County, Georgia, within 30 days of today's date. You are being sentenced under the provisions of the Georgia First Offender Act. Do you understand everything so far?
Yes, sir.
Okay. Now, although you do not have a felony conviction, and hopefully you will complete your probation and be discharged on this charge, while you are in the status of a first offender probationer, you may not possess or own a gun or firearm or any ammunition as that term is defined by the official code of Georgia. Do you understand that, Ms. Fisher?
Yes, sir.
Do you own or possess a license or a permit to carry a weapon by any chance?
No, sir.
All right. All right, that is your sentence. Now, when and where does Ms. Fisher need to report to the Department of Community Supervision? Officer?
I'm here, Your Honor. Mr. Guzman was just messaging me back. Being that she's living in Montgomery, we need her, I need an address, date of birth, social security number. Before you start say that, ma'am, you are on public Zoom and it's on record. But we're going to need to get that information. We'll have to do an intake via a video call like we're doing court now, and then start her transfer process through ICOTS. But we need to do that sooner rather than later. If it's done within the first, if the request is made within the first 7 days, it can typically be expedited. If not, it'll take up to 45 days. And they don't have to accept the transfer.
Well, you make a good point, Officer Stanton. This is a hearing that is being broadcast, or I guess is being transmitted via YouTube. The public can observe, therefore making this an open courtroom, and the doors of the courtroom are unlocked. But you most likely don't want to put your address and your social security number out there for everyone to hear. So let's do this. Ms. Fisher, when we conclude this hearing, call Mr. Guzman and give him that information, and Mr. Guzman will get that to Officer Stanton. Is that agreeable, officer?
Yes, so that will work just fine.
All right. All right, that's the end of our hearing. Do you have any questions, Ms. Fisher?
No, sir.
All right, good luck to you in completing your sentence without incident, so that in about 2 years' time, I can sign a discharge for you. All right, that concludes our hearings for the day, unless I've overlooked something. Ms. Flournoy, do you think we've covered it all?
I think we've covered everything, Your Honor.
Mr. Guzman?
Yes, sir.
All right, then we stand adjourned. Everyone have a good afternoon. Thank you.
Thank you, Your Honor.
Mr. Guzman, I also need that Brianna